Lord, I beg to mention, my lord, I have filed an additional affidavit today, my lord. I have served the copy to Government Council yesterday. So, my lord, it may be taken up, my lord, at 2 p.m., my lord, today. Item number 42, my lord.
Wait, wait, wait. Item number 15, my lord. Matter will be taken on Tuesday, my lord.
Tuesday, it's not possible. There are two different
Yes,
benches
your lordship's
on
may.
that day.
Yes, my lord.
You just say it 1 week because we don't have the clarity this time. 15. So both
Item
are
15.
presented. The prayer made by Learned Council to the petitioner this after a week.
Next week. Next week. Yes, Congress.
May I please your lordship? My lord, item number 1 to 6, my lord. My lord, Mr. Diganto Das is appearing in this matter, and on behalf of Mr. Diganto Das, he has requested me to mention this matter, my lord. He has some personal difficulty today, and if it is not inconvenient for your lordship, the matter may be taken up on Monday, my lord. And these are matters by administrative order, my lord. This has been assigned to DB2.
On the prayer made by Learned Council to the petitioner, list on 8, 10, 8, 12, 25. Okay.
Deeply obliged.
May I please, your lordship, item number 16, lordship, let me take on Monday, lordship, and I'm on behalf of P.S. Hajarika. He's at Kolkata, lordship.
Monday, we don't know because next week, many matters are being adjourned. We'll see it after a week.
After, yes, lordship.
19, item 16,
16:16.
same after a week.
Obliged.
May it please your lordship. I'd like to mention item number 17, my lord. Please, Mahmoud, after winter vacation, my lord.
Have to give a date after the date.
Lord, may I please, your lordship? My lord, I have planning item number 43, my lord. Since item 42 is already mentioned and both the matters are tagged together, my lord. Lordship will be pleased to take up both the cases at 2 p.m.
Item
43. My one is 43 and his item is 42, my lord. Tagged together, my lord, both the items. At 2 p.m, my lord.
okay, 42, 40.
Yes, my lord. I'm deeply obliged.
Daily list item 7 for motion.
May it please your lordship, kindly pass over the time being. Yes, your lordship. Obliged. Time being. Oh.
Item 8.
Under the incident final order, I issue Annex A, page 20, page 20, sir, my lord. Kindly see, my lord. The decision taken at page 24, my lord, paragraph 10, my lord. Summarily rejected the claim of the petitioner.
Page 20. 79, 2025, passed by so and so and so and so. Thereby declaring the petition to be a foreigner of post.
Lordship. Lordship, I just want to mention, affidavit is not complete, the mobile number is not there, Lordship, at page 19.
Yes, they have given it.
Mobile number is,
You should give it to them unnecessarily.
I will
Give it
supply the
right
mobile
now.
number. I will supply.
Give it right now.
नहीं, ये आपको visible लगे, अपना paragraph add कर दीजिए। ये तो सब,
Yes.
ये अपने mobile ही जाता है।
Yes.
Notice extra copies of the improvement. Copy the record to the federal to email. Sending requisition following each purpose of the event. Therefore, bail is opposed by the United States because the matters considering the position. And it's time to take bail with this 500, this satisfaction, for this bottle. It's only for page 2. This after 4 weeks. This will be 4 weeks.
Item 9 for motion.
And it was a call for the petitioner. So here from the respondents. Filing this petition, page 62. Opinion dated 28/8/2025, passed by so-and-so and so-and-so. See page 63, huh? Passed by so-and-so and so-and-so. Thereby declaring the petitioner, we have fallen off 25 to 19 Central Street. Notice available in 4 weeks, extra copies within 2 days. Copy the relevant record to email address with the following tabular. Fear for bail is the fear for bail as made in this petition is opposed by the London Standing Council for the FP matters. Considering the projection, 10 days time. Take bail. With this 5,000, this possible of police border, one for another. They start the progress in the second place.
Time being item 7 for motion.
Please, Your Lordship. Lordship would find the impugn order from page 47, Your Lordship.
But sir, am I sent and cost for the petitioner? So and so for the respondents. It is at page 58. It is 31/7/2025. Passed by so and so. In case number so and so arising out of PE number so and so. Thereby declaring the petition to be a problem of both speed. Notice returnable in 4 weeks. Extra copies within 2 days. Of the record shall be following email address. Here for bail is opposed by the Royal Standing Council for the FT matters. Pursuing the projection. And this time to take bail over this 5,000 to the satisfaction of. When the police border, Bokata. This type of rules on receipt of records.
Oh my God.
Supplementary item 38 for motion.
Two thousand twelve, this is release of 2012.
Yeah, opinion is of 2012, but yes,
Starting.
ex-parte and the petitioner has been detained. So we'll find the instructions because it says.
None appears on call for the petitioner. I was also, I heard so and so for the respondents. Next one.
Can find out where his father is lodging.
This is that whereabouts. Huh? This petition filed under Article 226 of the Constitution of India, it is projected that the father of the petitioner, namely Mahib, M-A-H-I-B, Ali, was taken into custody on 24/5/2025 from his residence, and thereafter the whereabouts of the petitioner is not known. Post office. It is also projected that after the detention of the father of the petitioner, information was gathered that by virtue of an
Lodging the ex-parte
party opinion dated
22/6/2012.
22/6/2012, case 30. So and so and so and so. The petitioner was declared to be a foreigner post 25 to 1917 Street. Next one. Accordingly, court is inclined to request the learned standing counsel for the home and FT matters to give instructions with regard to the whereabouts of the father of the petitioner, namely so and so, Mahib Ali, Muhammad Mahib Ali, in whose respect by an opinion dated 22/6/2012, passed by page 30, passed by so and so and so and so, was declared to be a foreigner post 25/3/17 Street. So the information shall be obtained from the concerned authorities under the Home and Political B Department. Expect the learned standing goes for the FT matters is FT and border matters is permitted to send a downloaded copy of this order to the concerned authorities, obtain instructions, list on. Giving it on 10th.
Extra copies we always said.
But the council is not, before that you say that the learned counsel for the petitioner shall provide copy of the petition as well as soft copy of the petition to the learned standing counsel for the FT and border matters in course of the day, so as to enable her to obtain instructions. List on 10th.
Supplementary item 39 for motion.
May I please, Lordship? Lordship, in this case, Lordship, impugned opinion is page 85, Lordship.
F.A. Hassan, learned counsel for the petitioner, and so and so for the respondents. Page 85. Opinion dated 34/2025. Passed by so and so in case number FT so and so. Reference IMDT case number so and so, by which the petitioner was declared. Notice returnable in 4 weeks. Extra copies within 2 days. Following email address of the learner. Appear for bail is opposed by the learner standing counsel for the active matters. Considering the projection. 10 days time to take bail. It's 5,000 to the satisfaction of Superintendent of Police Border Borpeta. Mr. to Police Solicitor reports.
Supplementary item 40 for motion.
Right.
May please your lordship, your lordship will find an impugn order on page 136. This is
Are you saying that? And so over the respondents. Opinion is at page 136. Dated 24/6/2025. As per Swenson in case number so and so. In first paragraph, we find doubtful case number. So and so dated 23/5/2006. Notice returnable in 4 weeks, extra copies within 2 days, the record to the following email address. The declared for bail is opposed by the learned standing counsel for the FT matters. Considering the projection. 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police in bracket border. Sonitpur, Tejpur. Instructor of Police on receipt of.
blind lordship.
Upgraded item
Sorry, my lord, item 38, my name may be recorded.
But we did not hear you. You have to call back again.
Thank you. My
We
name.
don't heard you. And we are online, everybody is looking at us. They will find that my lawyer was not there.
Yes, ma'am. I mean, let me.
Your client was there,
Yeah.
online. He or she saw that you did not argue. Now what to do?
My name will be recorded.
Yeah, ma'am.
Oh, bless.
upgraded item 31.
Yeah, please, lordship. My lord, this is a case where all parents have filed compensation case, for killing their son Abdul Khalik while he was in custody.
We'll take it up after some time. Let the other matters be over because hearing will take some time. We'll take it after some time. Let the other matters be over because there will be. Okay, so probably in second half, we'll take it up. We'll take
Second
up
half.
the hearing now.
Upgrade item 32.
May I please, your lordship?
Which one is it? 30.
32. Affidavit people restaurant number 4 fresh affidavit দেব বেশি।
Yes.
Gift orders.
May I please, your lordship? My lord, kindly peruse the order dated 1/9/2025, my lord. Fresh affidavit is directed to file. Earlier it to file হয়েছে। But till date not final.
Yes.
Okay, to the order. Please, the order.
This should stop this road.
Lordship, I'll have to give the instructions, Lordship.
You get the information because otherwise you have to.
Your name is not shown, so we missed this matter, Lordship. On the cause list, it's just GASM.
Oh.
Yes, lordship.
We have missed this matter, Lordship. Fresh affidavit deposed.
Because here, since this is filed as a
Maybe.
reputation criminal, this was not taken up as a foreigners tribunal matters.
Yes, Lord.
It was taken up by this, by the state. So,
Affidavit has been filed by us, Lordship.
Yes, please.
It's just SP
Golaghat.
Golaghat, Lordship. Government advocates can also take it up, Lordship, because
no, we are not on who is appearing, but your name is not shown. But yes, Mr. Payang had filed it.
yes, Lordship.
Okay, we'll give you some time then.
Lordship, our name may be reflected
Yes,
in the call.
Yes. Definitely. So AC Ahmed, counsel for the petitioner is present. As well as Mr. So as well as P. Sharma and additional senior government advocate are present. It's Mira. A. Verma, and standing counsel for the FP matters has submitted that the standing counsel for the FT and border matters had filed the affidavit for respondent number 4 on 27/8/2025. Sorry, 27/8/2025. So, however, as the cause list does not reflect their name, the matter was missed. Is for, and is granted a week's time. File an affidavit in terms of order dated 1/9/2025. Next, Mira. The registry shall reflect the name of SC, FT and border matters in the cause list while listing the matter next. Next, the learned standing counsel for the FT and border matters is permitted to send a downloaded copy of this order to the respondent number 4. The enable the said authority to do the needful. Next paragraph, list on. Fifteen, 12/2025.
15/12 लिखो.
Publish.
If her name is missed out, please inform her one day earlier so that she
Lordship.
remembers.
Lordship.
Upgraded item 35.
One name. I think I have one name.
Me please, your lordship. Here, your lordship, in compliance of the order dated 19/9/2025, you have taken steps on the respondent to by way of dusty service. And the affidavit is also there, which has been annexed in the record.
Mr. S, this one, the applicants. None appears on call for the respondent numbers 1 and 3. The the petitioners. Just make your submissions, just a moment. CGC appears for respondent numbers 1 and 3. And whether the it's transfer the applicant is referred to the affidavit detailed on
Delay.
31/10/25.
17 to 18 days.
Has submitted that the
Delay may be control.
was served on respondent number 2 by way of the state. On the perusal of the service report, it appears that the notice was received by one Meenakshi MWNAKSHI.
Yes.
Office Assistant from our CMD Secretariat, CMD Secretariat. Accordingly, notices. I mean, union of India, it is accepted to be duly served. None appears on call for respondent number 2. This is an application for condonation of 17 days delay.
Yes, sir, then.
Next, by filing this interlocutory application under section 5 of the Limitation Act, the applicant has paid for controlling the delay of 17 days beyond the period of limitation in filing the connected review petition against the judgment and order dated 13/6/2025, passed in WA 233 of 2024. Next. The learned CGC has opposed the prayer for condoning the delay. However, pursuing the explanation tenders, the court is inclined to accept the explanation as good and sufficient cause for which prevented the applicant from filing the connected review petition on time. Accordingly, the delay of 17 days beyond the period of limitation in filing the connected review petition stands condoned. First of next paragraph, this application stands allowed. Next, the registry shall now register the connected review petition and list the same.
Your lordship, in the next item, there is a delay of 18 days, 36.
Item 36.
Yes.
The copy may be supplied, not the copies.
Will, sir.
Before that, in the meantime, a copy of the connected review petition be served on the CGC.
Thirty-five or 36, no?
35, 36.
Actually, phone तारीख receive करेছে আমরা পাহাড়ে সময় লেখা নাই সকে here it is the same orders 18 days. Here the date of receipt by Meenakshi Phukan is 23/10/2025.
Oh, William is, William definitely do that, but the facilities are the player, and the square for the border traffic, border this. Then what are the Muhammad Asas? Mukuja Modini. But to get 912. They get the head over the Mother.
Peace. Peace. What's that? What's that? No. One is that. It's typing.
Twenty-three ten. No. DVF fertilizer value fertilizer corporation. Main application to her. Local correction can be. Yeah, I'm
Same order, here 18 days.
Obliged.
Upgraded item 37.
This matter may be taken after some time also.
After some. After some.
Item 10 for admission.
Apply করছি না গানটা।
Apply করবো দেয়া নাই। ওটা দেয়া নাই। Online, apply করা নাই। May I please your lordship. Lordship, as per the order dated 16/7/2025, directed to me to produce the original document of annexure number 1. This is the original document.
Sit down.
The whole decision. Order দিছে তাত apply কৰাৰ কাৰণে এই চাৰি দিলো এতিয়া কিন্তু যি ডকুমেন্টৰ ৰিকোয়ারমেন্ট হৈ আছে ডকুমেন্ট লাগে না
That day you showed us a fresh order by the administrative order for the translated copies. Just if you have a copy, please. Huh? I'll give it to my master. Mr. Hassan, just sit down.
Who is it? In this case, lordship petitioner declare foreigner, footstep 71, my lord. In the exhibit one in annexure one, due to religious persecution, the petitioner, grandfather, father of the petitioner, mother came from the East Pakistan, my lord. That is the exhibit one, my lord. They have come in 1955, that's citizenship certificate, my lord. Refugee relief.
Original দিলা
So, size.
এইটো আনিব কৈছিল
বুজা নাযায় বুলি কৈ বুজা নাযায় বুলি কৈ আছে এলিজিবল নহয়
এলিজিবল নহলে কি কৰিম যেনেকে তেনেকে Yes.
Question. Then after lordship, page 17 lordship, page 18, shielded my lord, in the year of 1969, my lord. Buddheshwar Mandal, late Kanuram Mandal, my lord, Buddheshwar Mandal is the grandfather of the petitioner.
Is that an exhibited document?
Not exhibited, my, this document is not exhibited.
First come to the exhibited document.
Yes, yes, Lord, I'll come on the exhibited document, my lord. Well, Botanist of 1970, father of the petitioner and mother of the petitioner. This is the exhibit number 2. Dhiren Mandal is the father of the petitioner and Aruniwala Mandal is the mother of the petitioner. This is the exhibit 2 in the Botanist of 1970.
Yes.
My lord, then after Botanist of 1971, Buddheshwar Mandal, Dhirendra Mandal, grandfather, father of the petitioner. Next page, page 26.
Yes.
Then after my lord, annexure 6, page number 27, Bhuta list of 1985, then exhibit number 4, Dhiren Chandra Mandal, Aruniwala Mandal, father and mother of the petitioner. Voter list of 1989, it is not a exhibited document, my lord. Then after my lord, voter list of 2016, father and mother of the petitioner, Dhiren Chandra Mandal and Aruniwala Mandal. This is exhibit number
Just
6.
a moment. Yes.
Vote of the, then after my lord, voter ID card of the father of the petitioner, Dhiran Chandra Mandal, son of Buddheshwar Mandal. School certificate of the petitioner, my lord, that is not exhibit 5, my lord. Certificate that Marini Mandal, daughter of Dhiran Chandra Mandal, inhabitant of Blaise Noyapara number 1, post office Noyapara in the district of Bongaigaon, Assam, left the Bhaitapara High School on the 31/12/1995. According to the admission register, her date of birth is 21/7/1979, my lord. Was reading in class 10, my lord. This is the school certificate, that exhibit number 5.
Yes.
Lord, then after voter list of 2005, the name of the petitioner and the husband of the petitioner after marriage, my lord. Petitioner name has been appeared in the voter list of 2005 along with her husband, my lord. This is exhibit 6, my lord. This document, my lord, voter list of 2005.
Yes.
Then my lord, voter list of 2011. Exhibit 7, my lord. This is the exhibited document. Petitioner name along with her husband name, my lord.
Yes.
My lord, then after the voter list of 2015, petitioner name Mayarani Sarkar and husband name Harihar Sarkar, my lord. Or then after my lord, voter list of 2016, name of the petitioner along with her husband name. And my lord, in this case, my lord, father has come and deposed, my lord, and said she is my daughter, my lord. The father deposition, my lord, is base 55, my lord.
Yes.
Base 55, my lord. I know the opposite party. She is my own daughter. Her age is 36 years. About 20 years back, her marriage was solemnized. My name enlisted in the voter year 2025 at Abhaipuri. Her husband name is Harihar Sarkar. I have casted my vote for the first time in the year of 1970. I have furnished the refugee certificate as Exhibit 1, where my name is reflected, my lord. Refugee certificate, my lord, the Exhibit 1. Due to religious persecution, they have come from the East Pakistan, my lord, in the year of 1955, my lord.
Yes.
Hmm?
We have. Or kill get a-
The learned foreigner traveler did not consider the DW2, my lord. We don't want to prove the link between my father and the proceeding, my lord.
Yes.
I pray before lordship to consider my prayer, my lord, to declare Indian citizens the petitioner on the basis of the exhibit 1 of the document and the cross of the father of the petitioner, my lord, DW2. And we have submitted all the voter list from the 1972 up to date, my lord. My father, my grandfather, my mother, and my name, along with my husband name, my lord. That may be considered, my lord.
Where is your written statement? Which page?
WS, my lord. WS, my lord, is page 42.
Seven. 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 আমি একটু করে আসি। Yes, Ms. Verma.
Lordship, the only document where the name of the petitioner and the parents are is in the school certificate, which was exhibited and not proved, Lordship. And Lordship, in her evidence, she has stated that she is the fifth child amongst total 7 children. The name of the other 7 siblings nowhere reflects in her written statement or in her father's requisition, Lordship. And since this school certificate has not been proved, Lordship, it reflects that she was born sometime in 75. Which page is your school certificate? Just a minute.
This school certificate, page 32, 31, 32.
Where is this 7 children is available? This,
Sorry, Lordship.
how does this 7 children, where is it reflection?
Page 46, Lordship. Appreciated of the opposite party for examination in interview 1.
56.
Paragraph 4, Lordship. That I am the 5th child amongst total 7 children of our parents, and including me, we all were born at village Naupara in the district of Bangalore. Nowhere else it has been stated, Lordship. If there were 7 siblings, at least some name ought to have been with the parents, Lordship. All along the voters list which my friend shown before this vote is only of the father and the mother. Neither with the siblings or with the petitioner also. And the only certificate which should have been in the school certificate also. I do not know if there is a seal here because it's an annexure, it's here. To the original record would say if there is a, if it's admissible or not, and this has not been proved. This lordship comes to the opinion at page 59. 7 8 lines below lordship, this certificates. Exhibit 5 is the 5th line lordship. This line, exhibit 5 is a school certificate, page 59 lordship. Exhibit 5 is a school certificate.
There's no seal here.
Lordship.
There's no seal here.
No, I'm not sure. I was just assuming because I can't make out it's written exhibit
Page number?
32. Thirty-two is the school certificate.
Oh, no, there's no seal. There's no seal. It's just a
Same paper.
appended to mark exhibit, I think, that has been there. Doesn't have that.
Yes, Lordship. This certificate was obtained only in the year 2016 after the proceedings started, Lordship.
No, but Ms. Verma, you have raised a pertinent point. I think you'll have to also that Mr. Paying was in the process of that SOP. You will also have to say there. We'll show you what has happened here.
Lordship, what happened to the other 6 siblings, Lordship?
No,
The whole family
just a
too.
moment. I'll come to, just a moment. Send back the arms. These are the exhibits. Not to send me.
Examination of performance. Yes. Examination submitted by the OP. Evidence. And evidence of DW2 are submitted. Yes, Your Worship. Your Worship, it's not right to get. Your Worship, it says token for. Some names of the voters list of 1970. Yes, not compared, yeah. Because or compared with the. Now you see what happened. The capital was then it is established. And now it is Worship, my submission would be this may not be an isolated case, there may be. SOP also. Has to be compared. Proceedings. Lordship has a point here. So Lordship, this would be another learning thing to put it in the SOP for the members. Lordship. Mr. Pine. That's okay. See, it's also actually. Yes, Lordship, this is a very important issue. Thank you for your.
One point your lordship is right, my lord. But yes, it is admitted, my lord, that the documents were examined. Documents were, the date was fixed for examination of document. This should not have been. However, my lord, my lord, as I always submit, my lord, this is a quasi judicial authority, my lord. The pure CPC may not be followed in each and every case. However, my lord, because this, yes, no, that, yes. And now, my lord, yes. No, my lord, not in all cases, that's my lord, because the there is the 1964 orders, my lord. Probably for this reason, 1964 order, my lord, the now, my lord, the order your lordship has shown that order 9816, my lord, and the next order. OP is present. OP has submitted WS and document. This document was examination of document was fixed. OP is present. OP is put. OP is
This case record.
Peruse. OP is
Yeah.
present. Peruse this here. Examine the documents submitted by the OP. This examination was done. Documents is examined. Fixed so and so for evidence on affidavit. And look, in fact, even though the documents were examined on 24/8/2016. Yes. Yes, sir. Yes, that is the point, my lord. When these can be raised only at the time of, my lord, the cross examinations and cross examination. Yes. Now, from my lord, yes. Yes, my lord, I'll look it. Generally, it doesn't happen, my lord. Generally, it doesn't happen. Sometimes probably here, what happened in this case, this is an isolated case, my lord. I have not seen where, my lord, the compared, originally is compared is not written and seen. Yes, no, generally I have not noticed this, madam. This is first time where it is noticed that the original is seen and examined. That part is not there in the affidavit, exhibits. Because in almost in other cases, madam, compared and the original is compared and it is either returned or kept in record.
No other siblings.
Huh? দেখাইছিলে নাই মিছে
See. Assuming it
is there.
Even also. Lordship, even if we assume that, then also the linkage is missing, Lordship.
Compared from this.
The exhibit 1.
Yes.
It was scanned. কাগজের উপর থুই স্ক্যান করে এটা।
Yes.
এটা ফটো কপি।
Illumination.
কাগজের উপর লগাই দিলে
তলটো ল্যামিনেটেড। সেইটো থৈ আকৌ ইয়াৰ ওপৰত লেমিনেট কৰিছে।
কাগজৰ ওপৰত থৈ দিলে
Logic, I cannot find, make out much. It is not laminated here.
Colored photo.
And Lordship, WS is to.
That is the mention in the WS manual in paragraph 5. Dhiren and Dhiren Chandra Mandal is 7.1%.
Again.
Page 43.
Self,
Page number 43. Paragraph number 5. Forty-three. Paragraph number 5.
Lordship, in 70, he is Dhiren, and in 71, he becomes Dhirendra Mandal, Lordship. Again, in 85, he becomes Dhiren Chandra Mandal. So, it's not consistent. Now, Dhiren and Dhirendra or Dhiren Chandra Mandal, Lordship, which it has to be one name. And then the epic shows Dhiren Chandra Mandal.
Yeah.
Under submission, the petitioner has failed to share her linkage with her father. With, Is the voters list lordship show discrepancies? Then the school certificate exhibited not proved. And the WS is also incomplete, though one he says he has siblings, but no siblings. Over here only. It's a case of pick and choose documents to show us if you're projected father and mother option. The relief certificate of the type copy lordship, here it is Dhirendra Mandal. But subsequently it changes to Dhirendra Mandal, Dhiren Mandal. And it is their own explanation that they are one and the same person. Yes, Mr. Biswas. S.C. Biswas.
My full.
Sachindra Chandra Biswas. And though I don't remember all seniors' full names, lordship. Subhash Chandra Bose. So it can be one and the same person, lordship, it means that. Practice. Yes, lordship. There's no infirmity with the findings of the tribunal lordship. And petitioner has miserably failed to show her linkage with her parents.
In 1955, you were 11 years. Correct?
Yes.
If you are 11 years, then this will make your date of birth, year of birth in 1944. Your relief certificate exhibit 1, that is 55. If you are 11 years then,
My father, my lord, that is my father.
this is your father.
Yes, Lord.
So it will be, age would be 19.
1955, his age is 7 years. Exhibit 1.
7 years.
Yes.
Now come to your the exhibit 1, your father's
Voter 70 lordship.
Hmm?
Voter
College
ID.
from 1970.
Yes, what is the age?
Age, my lord, 28 years.
28.
Yes, Lord.
So 1970 minus 28 is 1952,
Yeah.
1942.
This document is 1955. 1955 document.
So still not 1944. Then again, 1971, he is again 28,
Yes, 28.
43, still not 44. The age is not matching. 1985, he is 42, he becomes 43 then.
1955. Yes. 48.
89, the mother's name is not there in the voters list, and after 89, it's 2016. In between, no other voters list is next lordship.
Yes,
That's okay, mother is not important.
nineteen 55, my lord.
Lordship, assuming page 29 lordship voters list, there is 3 more Mondals there, lordship. So assuming they are the siblings of the petitioner, then also the petitioner's name doesn't figure out, lordship. Her voters list comes with the husband for the first time in 2005 at the age of 27.
Yes.
No document to show she was ever a Mondal, lordship, except the school certificate.
During the orders. But Mr. F. A. Hassan heard Mr. F. A. Hassan, learned counsel for the petitioner, also heard so and so for the respondents. Argument concluded, judgment is over. Take a short break and come back.
My lord, regarding the attendant board 12, it's our matter, my lord. So, my lord, to be taken after weeks, my lord. Attendant board 12.
Okay. What says the representative? Just after a week, pay for the learned counsel for the petitioner.
Whatever is the additional documents.
মানে আৰু আপুনি এটা বহিখন চাব লাগিব
এইকাৰণে কিবা আছে নেকি বাকী ভালে আছে দেখা নাই একেবাৰে বহুত দিন যোৱা নাই কলে
আপোনালোকে ফালে মাতা নাই নহয় খালি মাতিছে মই খালি বিলটো দি আহিছো এই যে গৈছিলো সেইটো পাই যাম
দাসে কোৱা নাই নে দাসৰ লগত কথা বলা নাই আমাৰ নৱজিত দাস
নতুন যে নাই কলিতা
কলিতা হৃদয় ৰবা ন মই এবাৰ কৈ দিম
কিন্তু চাই কৈছিলে দিব
দিব তেতিয়া
বিকজ ইমান শৰ্ট টাইমৰ মাজত কোনো কনফাৰ্মেশ্যন পোৱা নাছিলে But they like, chief LADC, you know, the full title is. আচ্ছা আপনার আপনি মোটে মুখ বেড়ে গেছে আপনার একটু সলভ করতে না হ্যাঁ নিজের মধ্যে একটা কথা
মই আপোনাক
নহয় মোক এবাৰ ফোন কৰিব দিব তেওঁ নাম্বাৰ তোমাৰ চেঞ্জ কৰা নাই তাৰপাছত আপুনি এবাৰ ফোন কৰিব দিব হা মই আনকালৰ লগত মই কথা পাতিম পাতি পেলাই এটা বনাই তেওঁ কি কৰে নাই সেইকাৰণে তাৰ আগতে অলপ ৰাস্তাটো কৰাই ঠিক আছে আপুনি আজিয়ে ফোন কৰিব হা মানে ৰাতি হলে দেৰি ৰাতি হলেও তেওঁক ফোন কৰাই যেন মোক এতিয়া তেওঁ নাম্বাৰ পাই যাম ন আৰু আপোনাৰতো এটলিষ্ট গম পাইছো ঠিক আছে আপুনি সেইকাৰণে আপুনি ৰিলিফত থাকিব এইটো আপোনাক মই কৰি দিম দিয়ক হা ময়ো কামত প্ৰেছাৰ দিটো পাহৰি থাকিম দিগদাৰ নহয় এইটোতো প্ৰফেচনেল কেনেকে থাকিম কওকচোন ঠিক আছে আপুনি খালি মোক সেইটো এবাৰ ক'ব আংকালক এইটো ফোন কৰাৰ কাৰণে থেংক ইউ গৈ আহো আৰু অফিচত গৈ আহো এতিয়াতো তাৰ পৰা বহুত দূৰ মানুহ আহিছে এই মানুহে দিদিনে ইমান কিয় হৈছে পইচা লৈছে বেচেৰা ৱাইফৰ কাণচুটি বন্ধ দি পেলাই বেচেৰাই কেছ পইচা দিছে তাৰপিছত জিপেও কৰিছে তাৰপিছতো কেছ পাৰিব নহয় বিয়া কেছ হওক ভাল কেছ হওক মই with money or without money, we have to do justice. We have to give our best. এতিয়া মানুহজনে যে এতিয়া মোক হেৰি চিটো দিছে মোক চব কাটি দিব বেয়াও লাগে ন মানে জিবে কৰিছে তো মানে বেলেগ মোৰ এতিয়া লিগেল মেটাৰ না লিগেল মেটাৰ মই মানুহজনক মাতিছো ডিটেকশ্যন কৰিছো কিয় আপুনি দিলে ৰিজন দিব লাগিব ন 19 অৰ্ডাৰ এতিয়া মই চেলেক্ট কৰিছো আৰু দিম ৰিজন তাৰপিছত মোক মানে সেইটোৱে ৰিজন ইভেন চাৰ্টিফাইড কপি অৰিজিনেল ঘূৰাই দিয়া নাই again take out the certificate copy. Yeah, you know, এতিয়া চাওক ইণ্ডিজিনিয়াছ মানুহ মানে মুছলিম নলওক কিন্তু ইণ্ডিজিনিয়াছ মানুহ সেইটোত লিও লোৱা নাই না চাৰ্টিফিকেট দিছে এতিয়া মই ৰিভিউ ফাইল কৰিছো ৰিড হৈ গ'ল ৰিড ডিছমিছ খালি এটা লাইন লিখিছে ইউ হেভ টু হাৰ্প অন দেট ন সেইটো যদি মই নকওঁ সেইটো
কি আনিলে হে হা চিংগুল নাই নাই বাইদেউৰো আছেনে নাই মই নাজানো দেই নাই এইটো গম পোৱা নাই আমিও তাকে পাতি আছো কিন্তু আজি মানে আমাৰ ছাৰৰ ডিভিজন ছিংগুল বেঞ্চ নাই বাইদেউৰো নাই ন তেনেহলে বাইদেউৰো যদি নাই তেনেহলে 4:30লৈকে বহিব মিটিং থাকিলেও 4:30 5টাতে থাকে
Very big. Yes. Yes. You got that? No, no, proceed. We are happy with it. He's so innocently sitting that that we are, we are in fact very sad that we can't entertain her here. She's always not following it. Now look behind, you will understand. There's an old Hindi song, "ए भाई जरा देख के चलो, आगे भी नहीं पीछे भी." Huh?
That she said, today your exam today, your exam today, she said. Lordship, and so just now, already
No, but we are not satisfied.
6 document was exhibited, Lordship.
Hmm?
6 document was exhibited.
You've seen the records now. One document is gone. The other does not, having not been exhibited by the concerned authority. Obviously, there's no link. We have to dismiss your writ petition even without hearing Mr. Pang.
Up to you, Lordship.
There's no answer.
Lordship, if possible, then be renounced by Lordship for.
In pass orders in the chambers, we don't say, we are not saying what we do want to do. We don't want to disappoint you in front of a very young audience. We don't want to disappoint you right now. We'll pass orders in the chambers. But basically, we are against you. What is the chocolate she likes most?
Lordship, no need, Lordship.
No, no, we don't want to. This young children will have to be tomorrow. Yeah. So which brand she likes most?
Lordship, because nobody to help Lordship, that's why I bring her.
No, I understand. I'm not, I'm saying I'm not, I'm happy with it. But what is the brand of chocolate she likes most? Will you?
Anything, and
But say she has a choice. Tell us. Tell us. Will you? Good. Thank you. But we'll detain you for 5 minutes. Illegal detention for 5 minutes. Just wait for some time. We are not equipped. So we'll have to equip ourselves, we'll detain you for 5 minutes.
keep your.
Item 13 for admission.
May I please, your lordship? My lord, the issuing order is at page 68, my lord. 8. And type copy starts from page 60, my lord. Type copy. My lord, as many as 21 exhibits were exhibited, but none of the documents were believed by the learned tribunal. May I read the impugn order, my lord?
Let the, close the documents first.
Yes, yes. At page 15. It was the exhibit 1, my lord. Exhibit 1. And this document was disbelieved by the learned tribunal because there is no seal of the controller. That is why it was disbelieved, my lord. And for that purpose, I have annexed 2, my lord, which is the mark sheet. That mark sheet supports, my lord, that admit card, my lord.
Yes. Please proceed, we are giving you. We are following you, please proceed. Yes. Please come to the English part, my system would have difficulty in reading this. Read from the English part.
English translation. Page 83.
Eight. Here.
This part seems to be certain later on, so like as stated by the outline. I did not also both the by the PCR and the basis itself then information and
Yes, Mr. I. Just to be serious. Hey, thank you, okay, it's here. It is, examination and cross examination. And many additions in 19. There are individual. Thank you.
This 905.
Here's what you see.
Yes.
Stage. Wherever they are registrar or so nature, everywhere there's an insertions. And this is that page of position of the. Position of the Qazi. See, first the signs it, the presiding officer. Then two lines are added, therefore it doesn't matter. Nobody will write a deposition like that.
Plus pages of different billion. The seat is.
So that we have a reason, we have an answer. That we don't. We cannot discard. The reason is they are using the, one, the form is old. But your party has signed it. Page may be different, but signature is not a manufactured signature. Something will take. Yes.
It seems, my lord, there is something, but
I cannot say whether it is inserted or not at this moment, because my lord, had it been inserted, my lord, because this is not the end of it, thereafter also the proceeding was going on, my lord. They could have raised this question in very, because this is not the, my lord. Thereafter also there are cross, my lord. DW4 was there. Had there been insertion, my lord, they could have raised this question in the tribunal itself, in the very that day, thereafter, my lord. Because this deposition was taken on, my lord, 12th day of June 2018. On 12th June 2018, thereafter, on 11th July also, another person came as deposed, my lord. Then 25th July also, there was deposition.
What is the which date?
That is on, my lord, 12th June 2018. This is DW3, my lord. This is like where it is doubted, my lord. Then DW4 was on 11 July 2018. Then DW5 one on 25th July 2018. 5 on 25th of July 2018. When they filed a written argument there in the tribunal, my lord.
No, Mr. Tahu, my lord. The submission of Mr. Ryan has posed. You see, come to page 84. You not like you said earlier because we're getting in big first. 84, my lord. It is from a record of 12 to what is 80, my lord. First line. The position of witness able to speak for the case for the solemn information on 12th day of June 2018, right? My lord. Now, on the right side, you have this separate copy, the court stands. You remember
Yes.
114 for 2114, dated 12/6/18.
No, on the same day.
On the same day, you took the certified copy, and it was given it to you. So if there was an interpolation, tribunal will have given this copy to you. That means the interpolation was copy, the right was already existing when you got the copy. You know, there's a process.
In fact, at page 85 under the right below, my lord. Certified to be true copy on 12/6/2018 itself. Yes.
Look at the date on the front.
Yes, that's in the ticket, my lord, it is there. Even in the, my lord, page 85, right below, it is also there, certified to be true copy on 12/6/2018.
And the better part. I don't. It doesn't say, well, we have a ID, but that ID is not there.
But line seems to be inserted like.
We said that.
My lord.
Don't be a activity.
My lord, however, this document was discarded because there is no sign of the touching. Now, my lord, in the writ petition, we have annexed the original one, my lord. Original one, my lord. That is at page 17, my lord. Page 17.
1/7.
1/7. The original one was also, my lord. And there is a seal, my lord, at page 20.
Yes.
My lord. Page 26, that is the, my lord, typed copy, and the Xerox one is at page 27.
Page number?
Page number 27. This document was exhibited as exhibit 8, my lord. And this is, my lord, issued by some magistrate court, my lord. And the name of the father is written there, Khaled Fatima. Father is the Khaled and mother is the Fatima. This was issued in the, on, my lord, 7/1/1960. My lord, exhibit number 8. 8. Now, my lord, can we come to page 37? That is the translated one, my lord. There is a periodic Khiras Patta, my lord. And the Xerox copy is at page 38, my lord. It was exhibited as exhibit 10. And the name of the father appears in the third line of the document we got, that Abdul Khalek Pita Kalu. The land was given in settlement in name of two persons we got.
We also had. Yes.
Yes. Next we got page 40. It was this below Jamabandi. 41, the Xerox one is there. And he had, both the patadas have got their name mutated.
Which page is that, now, Sanjeev?
At page 41. Yes, at page 41.
This is your evidence.
My lord,
Station for the vehicle one.
Evidence. DW1 or evidence? DW1 or evidence?
evidence. Evidence.
Not here.
Evidence has not been my lord annexed.
Where is the packet of that?
Is that.
Yes.
My lord, page 50. This is my lord Gowra certificate. He is certifying me, lord. And my lord, page 28. Page 28.
Which is your first voter list?
My lord, that my petitioners or fathers, my lord,
No, your.
mine. That is at page 42,
That is 1980, electoral 2005.
2005, my lord. And there my name is as Samsul Ali.
You, you please come to your affidavit at page 14. As per page 14, this Mohammed Samsul Haq is 42 years. So that will bring his date of birth sometime in 1977.
My lord, yes, 76. 76, my lord.
I don't know, 2019, January,
My lord.
if he's 42 years, then let us say 77. Correct.
My lord.
Now you come to page 42 42 and 43,
Yes.
this is a voter list of 2005. And he is 32 years of age. We have to make his date of birth in 1973.
Yes.
Because I have wanting to look old. And keeping my beard to look old. It's not popular, I am looking better.
My lord, so far as putting the age of a voter, that was, my lord, some discrepancies there, my lord, because those persons who put this, they put on assumption, my lord. This is the problem.
Let's say. Because in age 45, we have 39 years for the medical work,
Right.
That we should minus 78%. Suppose similar. From our photo, it's still about 1988. Okay, we'll forget that. Might continue with your.
Now, my lord, from all these documents, it is clear, my lord, the parents of the petitioner are in India, my lord, prior to 1987, my lord. And if your lordship come to section 3, of the Indian Citizen Act, my lord. Sorry, Citizenship Act, my lord. Section 3, my lord.
Yes, please read that.
My lord. Except as provided in subsection 2, every person born in India on or after 26th day of January 1950, but before the first day of July 1987, on or after first day of July 1987, but before the commencement of the Citizenship Amendment Act 2003, and either of whose parents is a citizen of India at the time of his birth, on or after commencement of the Citizenship Amendment Act 2003, where both his parents are citizen of India, or one of whose parents is a citizen of India and the other is not an illegal migrant, at the time of his birth shall be a citizen of India by birth. Because if somebody took birth prior to 1987, then his parents is not required to be Indian citizen without.
Yes.
Since there is no seal. By the child. Nowhere does it say it's signature. It's
Yes. Yes.
My lord. Date of birth exhibits, my lord. 14, 16, 14 to 16, 14, 15, 16 are not considered at all, my lord. Now, my lord, so far regards the age, my lord. Age, my lord, that was actually, my lord, put on the assumption. That is why there is a discrepancy respect of the age, my lord. Otherwise, my lord, if preponderance shows that this.
When you make a bold statement that this exhibit 14, 15, 16 was not considered, you compel us to read. Come to page 66. Two paragraphs are devoted on paragraph in exhibit 14, 15, and 16. Second paragraph, exhibit 14 and 16, a certified copy of voters list of so and so. He admitted that the DW2 in his cross-section admitted that he did not cast his votes for last 10 years. Correct.
My lord.
Now you come to the next exhibit 15 is proved in original electoral photo identity card. You have to show us that voter identity card is a proof of citizenship. And Mr. Payam will show you the judgments where it is not a proof of citizenship. Come to next paragraph. 14, 15, and 16 are not proved in accordance with the provision of Indian Evidence Act. Perhaps you are not prepared.
My lord.
Perhaps you are not prepared. Don't make statements which makes us read. You see, you'll have to find fault with the finding that since the marriage registers were produced but did not contain the seal and signature, is it a valid document? Can you negate that? And second, one of the documents you proved was a draft Jamabandi. Are you aware of the legal implication of having a draft Jamabandi? And what does it, how much it proves the contents? Can you tell us?
I thought that Jamabandi was exhibited in order.
No, please tell us first of all, how much fact does a draft Jamabandi prove?
Regarding the possession of the particular land.
No, I'm sorry. Draft Jamabandi does not prove anything.
My lord,
Draft Jamabandi, if you read the Assam Land and Revenue Regulation,
my lord.
you will find that first a draft chitta is prepared. From the contents of the draft chitta,
Yes,
when there is a settlement process going on,
my lord.
or otherwise directed by the assistant settlement officer, a draft Jamabandi is prepared. And then it is put up before the concerned authorities in the revenue department, who accepts it, and thereafter the matter is entered in a Jamabandi. So if there is any mistake in the draft Jamabandi, those are seen and corrected. And thereafter, under the land and revenue regulation, it is put up before the authorities and it is entered in the final Jamabandi. So a draft is only a draft. It cannot be a proof of anything. Let us say this is your arguments are being made. This is what I am doing. This is the only note I have made. It contains some figures, does not even contain any statement you made. But I can, looking at these figures, I can tell you how much you have argued for last 1 hour, 5 minutes. It is my way of writing. So if you prove this, let us say you take this transcribe and go to the appellate court and then say, this is what was scribbled by the honorable judge. Can this be a proof that I have not heard you? This is the only thing I have recorded. Nothing more.
My lord, otherwise the patta, my lord. The patta,
So therefore,
that was my lord exhibit. Yes. Page 38. That
yes,
settlement was given from the year 1975 to 2005. Meaning thereby, my father was here prior to 1987, 1st July of 1987. And I born in the year 1976 or 77. Well, by way of birth, I can get.
no, but how you are connecting yourself to your projected parents? That is the only query.
Yes, my father's name is there, my lord.
You claim that he is your father, but how do you connect yourself to your father? Which is the document by which you are connecting you with your father?
Yes, my lord, there's. Page 48, Abdul Khalek, that is the, my lord, voter ID. Again, my lord. Page 51 and 52, Abdul Khalek.
This is. Mr. Pine. You have this. You see, in these cases, I am telling you n number of times, unless you assist us by reading this unnecessary piece of bunch of papers, which you think is rubbish, you will not be able to assist us. Number one, you don't read the law. Number two, you don't read the facts. We are so sorry to say that the young lawyers sitting here, let this be a lesson to you all. Unless you read the law and the facts, will not be able to assist the court at any point of time. Yes, look at that flag document. Yes, this is exhibit 17.
Yes.
This sub-registrar was called and he sent his what you call assistant to the court. And he exhibited the original register. This is the original register. Correct. He's exhibited exhibit 17, next page, and then you'll find marking at 17(1), 72. Now this exhibit 17 is not even considered by the tribunal. It has got no mention of this exhibit 17. Now we'll show you something. We're sending you this. The first track you will find is the Muslim Marriage Registration Act, 1934.
Yes.
Correct?
35.
35, yes. Now you please see section 11.
Terms office.
What is it?
SARS officer.
Hmm?
SARS officer.
No. 11. Section 11. Of the act.
Rules.
The other is rules. First is that act. Muslim Marriage Registration Act. Have I made a wrong marking?
Rules, madam. Yes, registration act, man.
Huh.
Muslim marriage
11.
and divorce act.
Yes.
1943.
Could be 34, I think.
Yes, 35. Copies of entry to be given to the parties.
Yes. Please read.
On completion of the registration of any marriage or divorce, the Muslim registrar shall deliver to each of the applicants for registration an attested copy of the entry, and for such copy, no charge shall be made.
Yes. Now, one of the document which Mr. Sawa has shown us, you will find that signature is there. Seal is not there, but the signature is there. No, we are not finished with this. You finish with this book, then we'll come to again. Now come to rule, I think 24 copies again.
Rule 24, madam. Rule 24. When the Muslim registrar is present at the celebration of marriage, he shall make an entry of the fact the registered marriage, and copy of such entry shall be included in the copies of the made under section 11, 14, and 21 of the Act.
Yes. Now come to 31.
Yes, entry of marriage or divorce in the register to be signed. When the entry of the marriage of divorce has to be made in the proper register,
it shall be read over to the Muslim register over by the Muslim register to the person who, by section 10 of the Act, are required to sign such entry. If they admit its correctness, the entry shall then be signed by them.
Correct. Now come to 51.
Yes. A call for information from any court shall, if it necessitates search in the register, be accompanied by the necessary fee for search. Officers of government shall be permitted to inspect the register without fee, but if the production of a register in a court is required, it shall be produced by the Muslim register or other officer whom the district register may depute for the purpose, who will be entitled to claim payment of his expense like any other witnesses.
Correct. So now somebody is being sent. Whether it's right or wrong, that was never questioned.
Yes.
And this person came and proved it. Exhibit 17 is that entry.
Yes.
Now you can spend your time looking at this act and rules. It is nowhere required that every document or registration should be signed, should be affixed with a seal. You will have, who will have custody of the seal, but the mandatory requirement for a sub-registrar to put his seal is not there. It doesn't say anywhere, it doesn't say in the affirmative that document must be affixed with a seal. You will have provision for custody of seals.
Yes.
Mandatory requirement to have a seal affixed is not there. Second thing you will notice from each and every document.
Yes.
That the village is always some Dolani, Haluni or something. Village is not changing.
Kabil Nama, it is different village. Kabil Nama, it is different village.
Maybe we don't know the site where the marriage was taking place.
Yes. No, address of the petitioner, address of the Abdul Khalek. Her address has been written as Hukazan. It's not the village where the
He's having the original one, he's producing it before the court.
Yes, this is Hukazan village. Its original says Malad.
So it's okay, but otherwise all the documents are same. You see the land documents are Habitololi.
Other documents are same, Malad, but the Kabil Nama says it is the Abdul Khalek was a resident of Hukazan. The marriage was taken place in which place, Malad? It's a different address. He was a resident of Hukazan, and the Malad Fatima was a resident of Panigaon. This is their address. Their address is different. And
Presence in the country is there. If he has the original one, nobody will have any other person's original, what you call the copy of the marriage certificate. Now, this certificate was discarded, not on the ground that it is from a different village, but discarded on the ground that the seal is not there. And you see even if the seal is not there, once the original is proved as exhibit 17, how can the copy be discarded now?
Probably, my lord, this exhibit 17 was not discussed. The seal is not there, it is this,
No. You see, there's a reason for asking this specific question. Number one, you produce a certified copy of our order before some authority. Correct?
Yes.
Whether that is disbelieved or not, the authority, what it does is it requisitions our High Court record. Whether they can do it is a different question, but now they do it.
Yes.
And we send the original records. Now these original records, the original order is now before the authority. Now can it say that now I reject the copy, certified copy?
That is true, my lord. In fact, my lord, that exhibit 17 is not discussed at all, what I have seen.
Not discussed.
Yes.
You see, this we found it because we are meticulously going through the records.
Yeah.
Nobody else has time.
And the
We have all the
seal
time on the earth.
is not there, that has been, my lord, discussed with regard to exhibit 1.
Everybody thinks it is below their dignity to look at the trial court record. They are High Court lawyers. Why will they look at the trial court records? It's below dignity. And we both are the only ones who love the trial court records. We look into it. That's why Mr. Sahu said, you don't read the law, you don't read the records. If you can't assist us. At no given point of time, you can assist us when it comes to the trial court records. I'm not saying this to humiliate you. We are saying this to encourage young lawyers who are here to develop a habit of going to the trial court and then read the records. They must know how to read the trial court records. Now, when you discard everything, now there are documents which shows the name of the petitioner and the husband and the father. Can you neglect the chain of documents on the ground that it's a post reference document? And therefore, if they disbelieve the name of the father.
My lord, what happens in this case, what I have seen, my lord, obviously, my lord, in the opinion, the exhibit 17, the Kabin Lama has not been discussed. Otherwise, my lord, what I have
Forget about everything else.
Yes,
It shows the presence of the projected father at that point of time.
yes, my lord, now, my lord,
And you see, it says, you see why we are drawing a presumption. The Act and Rules says that a copy must be given.
copy
to
must
the-
be given.
To the person who has signed it,
Yes,
who are required to sign as under section 10.
yes, ma'am.
Now, it's not in dispute that the persons whose name appear in, who was required to sign under section 10 did not sign it. Now, this copy is produced. For him, that would be the original.
No, it is
But-
original, my lord, that I am not,
For
I'm
the
not
time being,
disputing
no.
that.
For the time being, we also accept that it is a copy,
Yes, it's a,
because the Act and Rule says copy,
yes,
but the original was produced.
yes, original was produced, my lord, that I accept, my lord, the original, there is a portion, from this record, it reveals, my lord, the Abdul Khalik and Fatima was there in 1959 when the marriage was registered. That is no, there is no issue on that one. But that is not discussed, my lord. There is no discussion on why it is discarded. There is no discussion.
But then the second question would be that how the periodic patta would be discarded.
The patta is of 77, my lord. Patta is of 77. Let's just start from 77. It's a post 71 document, my lord. This patta page 37, my lord. Periodic curious patta. This is from 1977 to 2007.
Okay.
Only issue, my lord, if your lordship may kindly see the 1971 voter list and others. The
Page.
page, my lord, 29, 28 is 28. This is in the Habidoloni list, my lord, where the petitioner is presently residing, my lord.
Yes.
This is in the Habidoloni. My lord, what my submission is, in the Habidoloni, page 29, my lord, the entries, their statement is this, it is Khalek Ali, not Abdul Khalek, my lord. It is Khalek Ali, son of Kalu, aged about 38 years, and Fatema Ali, wife of Khalek Ali, aged about 31 years.
Yes.
These two are the voters, my lord, in 1971.
Yes.
Now, the my lord, what my lord, though it is not discussed in the tribunal's opinion in the tribunal, my lord. My submission, my lord, I have seen, my lord, the person who engaged, who got married, he is not of Habidoloni village, of this village. That's a different village. So he has to say, prove, my lord, it is the same person who got married in 1959, and the person whose name is, my lord, Khalek Ali. Here it is Khalek Ali, there it is Abdul Khalek, madam. So whether they are the same one person, madam, and village is different. Villages are different, my lord, in both. Now, they relied on another voter list of 1993, my lord, page 31. In fact, the translated copy is page 3030, my lord. Here the first thing. Here to my lord, first time the name of Abdul Khalek has appeared. In fact, in translated it is Abdul, but original it is Abdul Khalek. Page 30 and 31. Here Abdul Khalek, son of Kanu Sheikh, is voter in 1993 only. This is the first time, my lord, Abdul Khalek's name appeared in the voter list. Page 30.
Yes.
And Fatema. This is also in the, my lord, the Habidoloni village list. Yes. Balidonga. Balidonga and Habidoloni, my lord. Balidonga, Saibora, Habidoloni, Kosarigao, Katoni Bosti, Urang Bosti. So somehow Habidoloni is there, my lord, right? But this is Abdul Khalek. So I presume, my lord, the Abdul Khalek's, my lord, what my submission is, that Abdul Khalek's name appeared first time in the voter list in only in 1993 as Abdul Khalek, son of Kanu Sheikh. And earlier, 71, it is, my lord, Khalek Ali, whose father was Kalu. There, now, my lord, that's why, my lord, even though it is not discussed again and again, my lord, it was very important to look the documents, my lord, the Kabil Nama, where one Abdul Khalek was there. My lord, but Abdul Khalek is of that Abdul Khalek is of a different beliefs. And this in Habibullah, it is in 1971 first documents, my lord, it is Khalek Ali, not Abdul Khalek. And this Abdul Khalek team first time appeared in the voter list in 1993 in Habibullah. Now he has to, my lord, my submission is that he had to prove that this Abdul Khalek, because we cannot accept Abdul Khalek and Khalek Ali is the same in one person unless he proved they both are same in one person, my lord. And now the Abdul Khalek, my lord, who is a resident of this Habibullah Kosarigaon Katoni Bosti in 1993, and that but Abdul Khalek, who got married in 1959, as per the, my lord, the Kabil Nama is same in one person. If he can prove is the same person, then his existence in India prior to 97 will establish, because we want that some documents where the petitioner's father is shown to be murdered in India prior to 1971. So if we murder the other documents, murder the Jamabandi, as your lordship has said, murder the Khiras Patta, it is also of 77. They are also, yes, they are also Abdul Khalek. It is not Khalek Ali, my lord. And father's name is Kalu. And the petitioner's name, my lord, who is identified himself to be Abdul Khalek, as per the admit card, my lord. But all along in the voter list, his name is appearing as Samsul Ali, my lord. Yes. Abdul Salam, who is himself identified himself as Abdul Salam by virtue of this, my lord, admit card as page 15. Samsul Haq, sorry, Samsul Haq, my lord. His name does not appear as in voter list because in the voter list of 1993 onwards, my lord, page 42, page 42, page 45, and even, my lord, the page 48, the electoral identity card, his name is Samsul Ali, not Samsul Haq, my lord. All the voter list from 1993 to 2000, my lord, 13, this was issued in 2013. If it is the person, he is Samsul Haq, not Samsul Ali, my lord, he should have corrected this name in the very initiative itself, because he is not an uneducated person. He is an educated person. According to him, he passed the SSLC examination, my lord. If he is the same person, Abdul Khalek, my lord, this Samsul Haq and Samsul Ali, all along his name is shown to be, my lord, what the voter list which he is relying, all along his name is shown as Samsul Ali, my lord. He has not corrected his name according to his, my lord, the admit card. Because admit card, it is only an admit card, it is Samsul Haq.
Mr. Hazarika,
Excuse me.
in the meantime, you may call Mr. Nath for that criminal matter. Yes.
So there are discrepancies in the name, my lord. There are discrepancies in the name, both father, grandfather, even grandfather name also, somewhere Kalu, somewhere Kanu Sikh, somewhere Kanu, and the petitioner himself. Only, my lord, definitely, my lord, only the, my submission will be, my lord, even though that, my lord, the 1959, that Kabilnama was not considered. On that ground, if your lordship may consider, otherwise, my lord, there are discrepancies are there. Obviously, the names is as well as in the, my lord, the father's name and grandfather's name also.
He'll go through the records and sit on 10th of December. Go through the records, then. But Mr. S. But Mr. S. Samudra is also the Krishna. And so for the respondents. The arguments are concluded. Stop. Next part. As the tribunal's records is voluminous, the court proposes to go to the same. Stop. Next part. List on 10/12/2025 for further hearing, if required. You have taken note of that submission. For further hearing.
Item 31, WP Criminal 11/2022.
And in this case, the petitioners are the parents, old parents. That is Abdul Khalik. He was killed by police after being arrested. He was taken to the spot where he kept dead body, and he kept the dead body. And at that time, showing the ground that he tried to snatch away the rifle of LDPO, was shot down. So this is the story of the other side. At that time, there was nearly 40 to 50 police personnel and other officers. And he was handcuffed from backside. So that is a totally false story. But till today, the always parents have come nothing.
কল্যাণী তুলে বলে যে ছিল still ওলাইছে রিপোর্টার স্ট্রিপ লেভেলে প্রিন্সিপাল পরিপালি করে যে মাথা মধ্যে পছন্দ করে এটার নাম এটা করতে What is the name of your son?
Abdul Khalek. Abdul Khalek alias Khalek.
Yes, sir. Next item. Next one, sir.
In details, it is stated in page 6, para 4 onwards.
What is the date of occurrence?
8/7/21. Was arrested on 7/7/21 on the ground that he killed one home guard, that is Iyad Ali. And he was asked to show the place where Iyad Ali was murdered. On that after 7, he was taken to the spot on 8/7/21 at about 1 p.m. And there But just for
Case study of the first case.
Mr. Nath and Mr. Mahmood, please tell us this, in this matter also, there will be two cases. First is the one in which the son of the petitioner is accused of murder.
Logic.
And the second case would be the unnatural death case of the son of the petitioner. Correct?
Logic.
First is this Bichni PS case. Bichni
Logic.
PS case 299.
Yes. In this unnatural death case, what is the status of investigation?
In this case, no, it is already trial has been analyzed and the other person's was given life sentence. And thereafter, the persons who have given life sentence, they are on bail. They are on
The
bail
police people are on life sentence.
The who were arrested afterwards.
In the murder case,
In the murder.
299.
No, no,
299.
that's why we are wanting to know. There are two cases.
Correct.
First, the trial is over.
Yes.
What happened in the UD case?
UD case, malad, that is 300, malad.
Yes, what has happened to that?
But at that point of time, the investigation was going on, that malad, up to the position I don't have now.
Mr. Mahmood,
It was,
the next query is to you. Please come to page 11. 11 of your writ petition.
Yes. Page 11.
We were thinking about this because you see, this criminal petitions we take up urgently. But at times what happens is that we start the hearing from the on the basis of materials available before us. And the there are certain things which we may at times it may escape our attention. That's why we are asking you. Now your prayer here is to declare the encounter as illegal and unconstitutional. But this is something which, in order to give that declaration, some sort of evidence would have to be taken. The High Court is not a court having original jurisdiction to examine things and then find out and give a declaration to that it is illegal and unconstitutional. You never made a prayer for inquiry by a judicial inquiry.
Yes.
Now, that's why we were both discussing the matter. Now, see, in the absence of a prayer for a judicial inquiry, even today, if we say we take up the matter within right earnest, we say we invoke our jurisdiction under Article 226, mold reliefs and ask for an inquiry. 2020, this writ petition is 2020. The date of death is 8/7/2021. Will anything fruitful come up at this stage by directing an inquiry? That's one part. Second is to start appropriate legal action against the erring police officers, so and so. That is your prayer. Now,
Another plan was also there to provide compensation of rupees 25,000, 25 lakhs.
so
it was a
My petitioner will issue
that's it. Now you come to your writ petition. The statement made here.
coming with it.
He was paragraph 4. That during investigation, police also arrested another person, namely Khalid Ali Abdul. Abdul Khalid was the son of the present petitioner. This Khalid Ali was arrested on 7/7/21 during the daytime. On that day at about 12 midnight, he was taken to the place of occurrence when Yad Ali was killed, and on the pretext that he tried to shoot the SDPO to escape from the police custody, the police encounter him on the spot. It is unthinkable that an armed person so and so. Now this is your allegation. But you please come to page 4. Ranjit Rajkhwa, Inspector of Police cum Investigating Officer of Bijni Police Station, he is the only respondent.
By name.
Correct, by name. And in this regard, you see, the issue before us is the act of the police officer who had shot your son, that is Khalid Ali Abdul Khalek. The person who is shot, in the absence of any inquiry, we don't know right now in judicial inquiry who has shot it. Maybe under the executive inquiry by the magistrate, something must have come up.
Magistrate was also there. Executive magistrate was also present here. And his statement is annexed here.
Where is that statement?
Page 23,
23.
23. What he had used before the trial court.
Twenty-three is forwarding, is
Next,
accused forwarding report.
Annexure 4, page 23.
24.
24 is also covered, but perhaps Rohit Rava.
Yes, Rohit Rabha. This doesn't refer to the incident on 7th. The killing of your son is not here. At least I did not find it. Please assist us.
It is not there.
Does this say about the killing of your son?
Said, yes,
Yes, sir, condition on.
he said that because there was only one person who was killed.
No, he is Mr. Mahmood. This magistrate went there for the inquest of Iyad Ali, not for your son.
But he said that,
Look at it, because I may have missed
he
it.
said that there were, can you see the next cross-examination part? We normally prepare two copies of inquest report, of which one copy is kept at our office. But I do not remember whether the copy of this inquest report is in our office or not. We were accompanied by about 40-50 police personnel. I have said before the police that I witnessed.
No, Mr. Mahmood, you are missing the point. You see, we started somewhere else. We showed you the nature of offense. We showed you the parties who are present here. And then we are asking you the prayer which you have made. Can we allow, in the absence of those persons who are accused?
Actually.
Now you see here, you are referring to page 25. In page 25, at least while I read earlier, I did not find anything against the against this respondent number 5. So therefore, to even give a declaration that the act of X was illegal, that X is not before us. Therefore, the only option you will have to only pray for that the issue of compensation, and that compensation would be only on the basis of the notification which they have. This way we are trying to find out, because at times we miss
We
the.
wanted judicial inquiry at an initial stage.
But that's not the prayer. For that, we have not asked the response of the government, and the initial prayer is having not been made in 2022. That's why we are asking you, if today, even if you allow it in your oral prayer, will it lead to any, will it give us any result?
No, actually, my lord, my instruction at the, before it is nearly more than 4 years already over. So the compensation part may be taken seriously, and in this regard,
Oh, no, Mr. Mahmood, we are serious in everything. We are serious in hard work, we are serious in smiling.
If a person gets nothing, seriousness has no meaning. Because since 4 and 5 years, 4 to 5 years, we have got nothing. And he was the only earning member of my family.
See, that's why we are seriously looking at it. That is why we have found out your prayer. We have found out the nature of
The first two, Lordship may.
judicial inquiry. If you want, then you'll have to send it for a judicial inquiry.
That may be done side by side, the if or Lordship on that, but our at present men, they are all parents, they are now extreme need of money. And he was the boy who provided them their livelihood. So on that part, Lordship, we kindly consider, then perhaps they would be satisfied, as I have heard. That part may.
Yes, if there's a police that, without going into the other aspects, why can't we pass an order that under the, under your, that scheme,
Yes.
We direct a compensation to be paid. The police inquiry, we don't go into anything else.
In that case, Lordship may follow the, Lordship's decision is there, Malad, in the other case, on the other day. In WPC number 4397 of 2024. The petitioners, in fact, husband was.
It's not this enormous burden to start.
No, in fact, the husband of the petitioner died while in jail, but ultimately in the custody of the police. So this, following the same principle.
This, that's the
notification-
principle. We don't
Lordship.
lay any,
Lordship.
what do you call,
Lordship has decided on 1/11/2025.
just give that number, Mr. Dan.
Yes, madam. 4397 of 2024.
4397.
4397 WPC 4397. No, Billy. Of
4397
2024.
2024.
2024.
That was part in jail.
It was in jail, in the under custody.
here
It was under
we
custody.
No, he is giving me an idea how to write that order.
So in my case.
He's
also,
assisting me to.
Bhanu Begum,
I don't know, I
Yes.
don't remember.
Kadbanat কিমান টকা দিছে, sir?
Bhanu
What is the date?
provided rupees 2 lakhs and then
What is the date?
matter is kept.
1/11/25. 1/11/25.
1/11/25.
In any case, this notification is.
It was my case. That was also my case.
It is running, you know.
No, this is under the victim compensation scheme. This is your another scheme,
Malad, Lordship.
not the victim compensation scheme. Because here that police, death in police custody is not there.
This is different.
That is in your other notification.
Lordship. But there is another scheme. Government को download को दिया. If it is in prison, it is in prison. Lordship. It was in custody. It was in custody. Malad, it is, yes, Malad. It is home. Home department has issued 27/12/24. It was in, if it is in custody, then cause of unnatural death and compensation amount they have said, it is maximum is 3 lakhs. 27/12. Malad, I'm sending it, Malad.
Hello? Maybe. God will see them, those parts now only for compensation. No, that is up to him. We will do proper justice. But we are at present on compensation.
Lanet Singh is also threatening me that God will see you.
Not threatening, is threatening.
Five by name, right? Hello. Look for person case study আছে. Look for
31
person case study আছে. যারা phone করিস. Look for phone করে দিই. এবার case study শুরু করি. Look for.
I have got the affidavit of DSP.
মই মেইলত দিছো দিব এই হেৰিত দিছো সোধাচোন মই মেইলত দিছো পাইছা নে নাই সুধিছো মেইলত দিছো তেখেতক মেইলটো পাইছা নে নাই সোধা মাতিছে এইটো এটা কাম কৰা এইটো নহ'ব আৰু এনেকে নহ'ব বাদ দিয়া ইয়াৰ পৰা যোৱা নাই মাতি আছে নাই নাই নহ'ব নহ'ব মই দি আছো ঘৰত তুমি যে মোক হোৱাটছআপত দিছিলা সেইটো দি দিয়াচোন তেওঁ স্কিমটো যে দিছিলা তাক দি দিছো মই দি দিম
Order dated 25/3/2022. This court had issued notice only on the respondent numbers 1 to 5. Accordingly, as no notice has been issued to
Right.
respondent number 5.
Can I take a leave for 1 minute?
Yes, yes. To respondent number 5, it would be appropriate to strike out the name of respondent number 5 from the array of parties. Full stop. However, it may be stated that Shukpa's report dated 24/2022 by this said person in form of a parawise comments has been received by this court on 21/4/2022 and the same is made a part of the court. Next para. The prayers made in this writ petition are threefold, 3-fold. Being within bracket 1, to declare the police encounter of Khalek Ali, son of the petitioners as illegal and unconstitutional semicolon within bracket 2 to fix the responsibility upon the police personnel comma who are directly involved in the so-called encounter of Kader Ali, Kader Ali, alias Abdul ABDUL, Kader Kader on 7/7/2021. Comma, and to start appropriate legal action against the police officers. Semicolon. And within bracket number 3. See, it's only 3, and not number, only 3. To provide a compensation to the extent of rupees 25 lakh to the petitioners. Full stop. Next para.
No, no, jail. Prisons.
Next para. Having noticed that there's no prayer in this writ petition for ordering a judicial inquiry, and moreover, as this court in a writ petition may not have jurisdiction to call for to record evidence, comma, the learned counsel for the petitioners has submitted that he would press the third prayer for awarding of compensation to the petitioners owing to death of their son, Kader Ali, alias Abdul Kader, on 7/7/2021.
Son's
Name is Khalek Ali alias Abdul Khalek.
No, Kader Ali likha ase.
Come to page 12, that is your prayer. I'm reading from your prayer. If the name is wrong, then look at your prayer at page 12.
Khalek Ali. Page 11. Khalek Ali alias Abdul Khalek.
No, look at page 12. I'm reading page 12 of your writ petition, line number 5. The so-called encounter of Kader Ali alias Abdul Kader. Am I wrong?
Well, it is wrong actually.
It is wrong.
That is wrong.
Khalek Ali.
It's,
I'm sorry.
the one who
It is written Kader Ali, but it will be Khalek Ali. Everywhere it is Khalek.
Abdul Khalek.
Khalek Ali
Khaled.
alias Abdul Khalek.
Khaled. Para 4.
Okay,
Para
please
4.
give the spelling. My secretary will write that.
Para 4.
Para 4.
Repeat.
Khaled. D.
In the prayer is reflected wrong.
Khalek. Khalek Ali
Para 4.
alias Abdul Khalek.
Okay, Khaled, Khaled, Khaled Ali, alias Abdul, ABDUL, Khaled, Khalek.
Yes.
Okay. Press the prayer for compensation on the questions. Next para.
Khalek.
In brief, comma, the case of the petitioners is that in order to investigate the death of one Yad Ali, YAD, Yad Ali, for which Bijni PS case number 299 of 2021 was registered, the police personnel had arrested the son of the petitioner on 6/7/2021 during the daytime to stop at about 12:00 midnight, he was taken to the place of occurrence and thereafter the police alleged that the son of the petitioner snatched the service pistol of the then SDPO, Bijni, you write the full sub-divisional police officer, then within bracket SDPO, Bijni, and tried to escape. And when he did not surrender despite warning, the son of the petitioner pointed the service pistol towards the police, for self-defense and to recover the government property, the police personnel resorted to controlled firing at the non-vital organ to stop. As a result of bullet injuries, you say consequent upon receiving bullet injuries, the son of the petitioner was evacuated to the nearest medical center at Bhetagaon, Bhetagaon, CHC, Bijni, for treatment. However, the attending doctors declared the son of the petitioner to have been brought dead. Next paragraph. The learned counsel for the petitioner has disputed the police projection and has submitted that when the son of the petitioner was accompanied with many armed police personnel, it would be unthinkable that the son of the petitioner, whose hands were tied, and or handcuffed, would try to snatch police pistol and try to shoot at the police personnel.
E2.
It's.
I mean,
This is an app.
logic.
I find it very strange because we don't have a what do you call the postmortem report or a inquest report here. It's never called for. We are trying to see the orders.
It was not, the inquiry report we have annexed, inquiry report in the additional affidavit. we have
That is by the magistrate inquiry. No, but what happened to the? Have you seen Mr. Mahmood?
No, pilot.
You, few moments ago, before you said that it should be taken up with utmost seriousness. And now you are holding the brief for since 2022, you never called, asked the call for the, at least the
Okay,
postmortem report. The nature of injuries are not there. In order to show us the injury report, you file an affidavit in reply where you annex the statement of the police officer in the earlier case. It doesn't help you.
Police has filed affidavit, Pablo.
No,
We don't know, we never asked for it.
no, it is not there. It is not there. No.
Stop.
It's not there. You only put-
Be that as it may, we find from the previous orders that that in the absence of any prayer, neither the postmortem report nor the inquest report has been called for. So stop. Nonetheless, in view of the fact that the learned counsel for the petitioner has pressed the third prayer in the writ petition, the matter is being taken up. In the absence of the said vital documents. Next paragraph. On the nature of pleadings made in the writ petition. And the affidavit in opposition filed by the respondent number 3. On 18/5/2022 and 19/9/2022, the court finds that there is no dispute with regard to the fact that the son of the petitioner was taken into custody on 6/7/2022 and that in the intervening night of 6/7/2022 and the morning of 7/7/2022, the son of the petitioner received bullet injuries and he was brought dead at the
Now, if your lordship kindly see, the affidavit by DSP dated 18/5/22, para 33, there is mentioned everything.
18.
18/5/22. The DSP has shown an affidavit with the honorable court. And page 33, G onward, G, H, I, and J. In H, it is said Abdul Khalik was critically injured and was taken to Bhetagaon CHC, where he was declared
You are reading at which page?
page 33.
Okay.
44, I think.
Of the DSP has shown in two affidavits.
Respondent number 3 is at first.
So that we have already referred.
First affidavit.
We have already referred in
Yeah.
that.
The here postmortem report matter is also here.
Where is it? Postmortem report, we missed it. Where is that postmortem report?
No, report is not there, reports matter is mentioned.
No, you see, mentioning of matter and then we are dealing with a criminal writ petition.
I only.
Passing of orders in the absence of a, what do you call the postmortem report and the inquest report.
Yes.
Tomorrow we will be a laughing stock of the society. That the courts have determined the compensation without the absence of the document, but you never called for it. It is, we are constrained, therefore we are constrained to record in the order that this will happen.
I have only just pointed out paras of the.
No. But today, for the first time, we are surprised to know that it doesn't have, we don't have the records of the earlier case. We don't have the records of the UD case. Mr. Mahmood, because we have to take responsibility of our orders. Mere absence of things doesn't exclude us.
In UD case, they would know better.
It's okay. Was taken to this what is it, hospital? What is the name of that hospital? I forgot somewhere it was there. The hospital, some so and so hospital, where he was bonded. That. What is the name of that hospital where he was taken?
Bhetagaon CHC.
Bhetagaon CHC. Okay. Bhetagaon CHC. There's no problem. Full stop. Therefore, comma. For all intents and purposes, comma, the son of the petitioner was in police custody when he died due to police action.
So personal there. Personal there.
Again, that's the
Full stop. Aspect. Yeah. Next para. It may be appropriate to mention at this stage that the issue of liberty of citizens, that with regard to the issue of liberty of citizens, the court has to place reliance on the facts and the evidence on record. Full stop. Therefore, it is not open to this court to draw presumption against any police personnel without material against such police personnel. Full stop. Nonetheless, comma, in exercise of power under Articles 226 of the Constitution of India, comma, the court has the competence to take note of the fact that, be that as it may, comma, the son of the petitioner, namely Khaled Ali Idris Abdul Khalik, had died in a police action in the intervening night of 6th and 7th July 2021. The court would be inclined to give that notification, inclined to take note of the state government notification.
Sorry for this.
Notification. This is the number, the top. I'm just marking the number so and so. Dated 27/12/2024. Issued by the government of Assam from a Home Political Department, by virtue of which due to death but this doesn't cover police action.
No, exactly this section doesn't cover in the other case, the spirit lordship has taken the spirit law. In fact, while passing the order, Ali Hassan case has been relied in the order. The one boy, he died in lockup.
5 lakh rupees.
5 lakh rupees, lordship.
Don't have that notification.
Oh, this is for prison. Prison.
So. Or the petitioners would be entitled to compensation in view of violation of the rights guaranteed under Article 21 of the Constitution of India. Post office. Accordingly, the court is inclined to direct the state government through the Home and Political Department to pay a monetary compensation or rupees 5 lakh within bracket, rupees within bracket, only bracket close. So the petitioners, namely so and so, there are two petitioners, namely so and so, being the next of the kin of the deceased, Khaled Ali alias Abdul Khaled. In the following manner. A sum of rupees 2 lakh within bracket in words, bracket closed, each be converted into two fixed deposits of rupees 1 lakh each. Again, that rupees 1 lakh only each, bracket closed, for a period of 5 years in the name of so and so within bracket petitioner number 1 and so within bracket petitioner number 2. The balance amount of rupees 3 lakh shall be released equally to the petitioner number 1 and petitioner number 2 in their bank accounts. We direct the petitioners to provide their bank accounts particulars to the Secretary to the Government of Assam, Political Department, while forwarding a certified copy of this order before them for compensation. Next para. That was A and B. This is now regular paragraph. Thereupon, the Secretary to the Government of Assam, Home and Political Department shall verify the identity of the petitioners and on being satisfied, make disbursement in the manner as indicated above. Next para. It is made clear that the award of this compensation is palliative in nature. Which does not preclude the right of the petitioners to approach the appropriate forum of the court in the event they feel that the compensation is not appropriate, which shall be done in a manner, in such manner as the petitioners may be so advised. It is made clear that in the event any higher compensation is paid, the same said amount would be adjustable against the palliative compensation granted by virtue of this order. It's the, the whole thing, other degree, happens at very good. That's not. Question about, stands about to the extent as indicated above.
Time to.
Yes,
Lordship, I mention item number 41 of
just tell the court master because I have a meeting right now.
yes,
Please
Lordship,
tell the court master.
Wednesday, Lordship.
We don't know, just
Yes,
tell the court master because
Alright.
we have many matters fixed.
Of like,
Tell the court master.
Monday, Milord.
Monday may not be because Monday we have many matters fixed.
Then Wednesday, Milord. This what.
Let the court master take a decision. I'm not